to be in a room with people. I think I was here with Rod 2 years ago, so anyway, it's wonderful to be able to come together in this environment. I'm Luke Woodward. I'd like to welcome everyone in the room today and all those people who are also participating by live stream. I'd also like to acknowledge the traditional owners of the land we're meeting on today, the Gadigal people of the Eora Nation. Gilbert and Tobin is delighted to be able to support the work of CEDA across many dimensions, but in particular has really been delighted over 11 years now to be able to host this event. That's, I guess, we kind of operate in an environment where economic regulation of kind of markets is critically important to our clients, and the ACCC is central to that, and CEDA is central to that. So that's important for us to be able to support those institutions. I'll move to kind of the introductions in a moment. Just to note, the format, many people will be familiar with it, but Rod will deliver the ACCC's priorities and policy update. And then a feature of this event has been the opportunity to engage with the ACCC Chair through a Q&A session. So we'll have that after Chairman Rod's remarks. So look, as you listen to the presentation today, I really do encourage you to think of key questions. There'll be an opportunity to post those questions via the Pigeonhole app. We'll all get to see my tech savvy in real time, but it's very simple. So I do encourage you to do that and think about that. And those questions get posted up and you'll be able to vote on them, and we'll work through those. It's really an honour to personally introduce Rod Sims, Chair of the Australian Competition and Consumer Commission, to deliver his 11th presentation of the ACCC's annual Enforcement and Compliance Policy Update. After 11 years at the helm of the ACCC, Rod, of course, truly needs no introduction, not just to this audience, but to the broader Australian community. This is an important event in the ACCC calendar. As Rod has explained over the years, the volume and breadth of matters that land on the ACCC's desk each year, the need for priorities from a resourcing and focus perspective is obvious. But the ACCC has always sought to bring more than a clinical resource allocation approach to that task. It has brought a clarity of purpose and a focus on what it needs to do to bring important issues to the surface and where we need to change conduct. And I have no doubt that each year that's a challenging task for the Commission. For 11 years, Rod has led and guided the ACCC's internal priority policy update review process, and I'm sure we can all see his personal fingerprints. They've always been there to see Rod. But just as importantly, Rod has been the champion of communicating the ACCC's priorities and explaining them. And this theme really goes way back to the first CEDA presentation that he gave in June 2012. And, excuse me, I'll try to reduce paper by just ripping off the front page of your speech in 2012, Rod. And Rod, in really his just first remarks, said, today, this is 11 years ago, my theme will be improving the Australian Competition and Consumer Commission's communication. It is crucial, firstly, that any institution such as the ACCC takes responsibility for how it is generally perceived. Secondly, that the ACCC explains its actions clearly. And thirdly, that it is seen as a champion of competition and consumer protection and speaks out accordingly when appropriate. And that's been the hallmark of Rod's leadership of the ACCC, and as reflected in his presentation here each year, but really, I guess, the entirety of kind of Rod's leadership and of the ACCC in that period of time. So without sort of further ado, if you could join with me in welcoming Rod to the lectern to deliver the ACCC's 2022-23 priority and policy update. Rod.
Thanks very much, Luke. Get these right. Now, I've got I should just say straight off, I've got a 30-minute speech which is going to be condensed into 20 minutes. So if you see a bit of fumbling about a bit, that's when I'm trying to paraphrase things, but I'll see how I go. Most important, I really want to thank CEDA again for allowing me to use this venue to announce our priorities. This is the 11th time. I think you've just reminded me, Luke, that Gilbert and Tobin has sponsored it every time as well, so I must give Gilbert and Tobin a lot of thanks as well. But it's really, I deeply appreciate CEDA making this venue available, so thanks, Jet, and if you could pass that on to Melinda as well, that would be great. As Luke just said, actually, I think in my first address I did stress the importance of us communicating to the public about the various issues on our plate, and I do believe very strongly that just by identifying and communicating issues, that actually changes behaviour. So it's a very important part of what we do. Now, our enforcement priorities this year, I mean, we're announcing them for the coming financial year. That's what we've sort of changed our approach a bit. So these are the 22-23 priorities. I'm obviously announcing them as on behalf of the ACCC. Even though I'm not going to be here for that period of time, it's still, this is very much the priorities as set down by the ACCC. And we do our usual consultative process to work them through. So I think it's an exciting list of priorities. I think it's a really important list of priorities, and I'm delighted to be announcing them today. So I'm going to do this in 4 bits. I'm going to talk 5 bits. I'm going to talk a bit about consumer priorities, then competition, then product safety, a bit on infrastructure, and I'll just finish up with a couple of comments on mergers. So our first consumer priority is going to be environmental claims and sustainability. This is obviously a growing issue for consumers. We all know that. But we're certainly seeing greenwashing as a concern for both consumers and for businesses. And that's the second part of that is really important as well. Consumers are unable to determine whether the claims made are true or not, so we judge it's our role to make sure they're true, otherwise we'll take action. And businesses, of course, many of them incur the costs of genuine environmentally friendly manufacturing processes, but they'll face unfair competition if they're competing against people who make the claims when they're not true. So that's what we'll be focusing on, but it won't just be the competition consumer, it'll also be hearing where businesses seek to gain advantage by making claims about the carbon neutrality of their production process as well. And in doing this, we're going to work very closely with ASIC and the Clean Energy Regulator, both to share knowledge and discuss the topics, but also to make sure we've got the right organisation dealing with the right issues so that jurisdictions aren't being crossed over. But it will be a major focus for the ACCC in the year ahead. Secondly, advertising and marketing in the digital economy. Now, I mean, it's just fundamental. If we are going to use data correctly, if we're going to get the benefits of data, we really need well-functioning online markets where people aren't misled and so forth. And what we're seeing is an increasing use of what we term, I think what other people term, dark patterns. And this is techniques where you've got false scarcity reminders, low stock warnings, false sales, countdown timers, targeted advertising using consumers' own data to exploit their individual characteristics, pre-selected add-ons. I mean, love little stories about going through and putting things in your cart, and then you're just about to go and complete the transaction, all of a sudden something else is in your cart. How did that get there? And you're paying for it. And then the other one, which of course we all love, is how easy it is to subscribe for something and then how difficult it is to unsubscribe. So all of this matters, and it's something we are going to take a great interest in, as well as manipulation of online reviews, and also social media influencers, which are telling you about goods without actually explaining they're getting paid a bucket load of money to do just that. And that, of course, distorts what people buy, distorts how much they pay, and distorts them buying things they probably otherwise wouldn't have. We have been successful in some of our areas in this area. Our case against Trivago we're very proud of, because we had a team of people about a third of my age who unpicked the Trivago algorithm, which was really very, very clever. And of course we won our Google location case. So we have had some success in this area, and we do have quite a lot of skills in this area. But we also strongly believe that if we're going to deal with this, we do need extra tools. And one key tool we need is an unfair practices provision, because it won't always be misleading behaviour, it will be unfair practices. And if we're going to make the best use of data, if it's really going to work for our economy and consumers are going to accept it, we're going to need such a provision to make it workable. So that's a really important reform we will keep pushing for. Obviously, issues to do with the pandemic is the third area I'll mention. When the pandemic came in, of course you're all aware of those authorisations we did, but the other thing that we did, which probably took even more time, was a task force dealing with consumer complaints, where they were booking things that actually got cancelled. They had gym memberships which kept on getting deducted, but the gym was closed. We had to work very quickly on that. I think those in the field know that the consumer guarantees didn't apply. We had to actually look at the terms and conditions that people signed up for to decide whether, when a company said you're not entitled to the refund, that was true or not. So we had to actually look at the terms and conditions. It was a really detailed bit of work. I'm really proud of what the team did on all that. We worked directly with over 100 companies. We got millions of dollars of refunds, and hundreds of thousands of consumers benefited out of that. Now with Omicron, you've got, again, consumers being out of pocket, but we're now seeing issues where consumers who accepted credits are having trouble being able to realise those credits. So that's where our focus is going to move to. We also did a lot of work on rapid antigen tests. I did a few press conferences on that in January in the sunshine, and came away with sunburn as a result of that. But nonetheless, they were, I think, quite useful. And so we'll just keep adapting to the issues. Hopefully they will subside as the pandemic subsides, but I suspect there'll be enough issues to keep us very busy. The fourth one is pricing and selling of essential services, particularly energy and telecommunications. And as I've said many times before, we do too much work in these areas. We're taking action against these companies too often, and they need to address that. We hear concerns about the lack of transparency in agreements between essential service providers and small business and consumers, misleading claims, and often this has disadvantaged and vulnerable consumers who are in the worst position in relation to these essential services. We've taken a lot of cases, as I mentioned, and I think those companies have got to do a lot better so that we're taking less cases. Their KPI has to be that we're not taking them to court every year. And of course, you've also got an energy sector going through massive transition, and so we're going to make sure that people aren't taking advantage of that transition to overcharge consumers. The fifth one is consumer guarantees. This is the area where we have the most complaints coming in. It's a fascinating area. We've had some fascinating, disappointing cases in this area. We get a lot of complaints in relation to motor vehicles and caravans. A lot of emails on motor vehicles and caravans because, of course, they're huge purchases. People are, the biggest purchase you make after your house. And one particular issue is that the dealers with motor vehicles, and to some extent with caravans, they cite difficulties in being indemnified by the manufacturer as to why the dealer can't give the consumer guarantee remedy to the consumer. So we think the time is ripe for law reform. I think I mentioned this for the first time actually a year ago, or maybe it was 2 years ago, whenever I was sitting on this stage last. We think we need to have law reforms so that non-compliance with consumer guarantees is a breach in and of itself, as distinct from right now. You don't have to comply with consumer guarantees. I hope I'm not telling you something you haven't worked out yourself, but you don't have to, as long as you don't tell anybody they don't have any rights. So it should be illegal so that you have to comply with them. And also, just as important, we've got to make it illegal for the manufacturer to not indemnify a supplier that does in fact give a legitimate consumer guarantee, consumer redress. And look, lastly, I'll mention small business. It's always been a key priority of ours, certainly a key priority of mine. Small business and franchising. We'll particularly focus on agriculture, where we've got some very important codes of conduct, dairy, horticulture, but farmers often are on the receiving end of dreadful unfair contract terms and otherwise dreadful practices, which again, an unfair practices provision would help. In the franchising sector, we're seeing franchisees harmed by potential breaches. We've got litigation against the Retail Food Group, just as one, but we've had successful cases against Jump Swim and Megasave. So we do a lot of work in franchising and we'll keep doing that. It's a business system where the franchisor is in a very dominant position versus the franchisees, and so we'll continue to take enforcement action to make sure advantage isn't taken of that unequal position. So that's the 6 consumer things, and if you want to know more detail, as I say, it's in the speech because I'm paraphrasing to make sure that I meet my timetable, and I'm already behind, Luke. Competition priorities. We've had a number of important competition matters before the court with some success, number of matters that haven't gone our way, but I think that's to be expected given the complexity of the law we enforce, but it's not going to dampen the resolve of the ACCC to keep taking these cases. That is what we are here to do. Of note, from my point of view particularly, the New South Wales Ports case has raised, I think, absolutely critical competition issues. I have to say I was very surprised, you could argue stunned, by that the case did not go our way in the first instance. Our appeal's been recently heard by the full federal court, but regardless of the ultimate outcome, we consider there was clear and significant competition issues here as the Port of Newcastle was effectively prevented from developing a container port that would compete with Port Botany. I seriously think that's unarguable. When the result of the appeal is known, I think we need to reassess whether we need to change laws to adjust to the court's interpretation of consumer laws. So I think this is a seriously big competition issue. Look, we've got a lot of cartel matters on at the moment. We've got about 6 cartel matters before the court and a number of matters on foot. I suspect our portfolio of cartel cases is as big as it's ever been since I've been here, which, I mean, keeps our cartel people busy, but is not a good look for the economy, so that's very concerning. We've got a healthy program of competition enforcement work at the moment, 4 matters before the federal court, including a matter that's just been decided in terms of liability, where the court found that both the CFMMEU and Hutchison engaged in a boycott. This case reflects the priority we've given to commercial construction matters, but it's got clear implications for the construction sector. I mean, who is deciding which subcontractors can go on a construction site? This matters for the cost effectiveness of our construction sector. I hope these lessons are learnt, but if they're not, the ACCC will act again. Now, in the part, I mean, we've got our standing priorities of digital platforms and financial services, but we've got 2 new priorities. And I'll come back to digital services and financial services at the moment, or digital platforms and financial services. But our first new competition priority is competition issues in global and domestic supply chains, particularly where they've been knocked about by the pandemic. Obviously, we've had the effect of the COVID-related staff shortages, the congestion that's disrupted supply chains. We all know about that. But we are concerned that they're going to get or have been taken advantage of to raise costs and bring about illegal coordination. These issues aren't unique to Australia. I was pleased to announce recently that the ACCC has joined with our fellow competition enforcers in the US, the UK, Canada and New Zealand to form a Five Eyes working group. This group is going to share intelligence, it's going to work together and see how we can pool our knowledge to see what's going on and detect collusion. And we won't hesitate to take action, and nor will our international colleagues. The second new competition priority is exclusive arrangements by firms with market power that affect competition. So, of course, we all understand that one feature of markets is that businesses do seek to raise entry barriers. That's what all businesses do. And they do that through exclusive supply arrangements. Often those exclusive supply arrangements are benign, but we're seeing examples in Australia of large and powerful firms engaging in exclusionary behaviour that damages competition. We're particularly concerned when firms with market power restrict access to bottleneck goods and services, which affects the ability of competitors to come in and actively compete. And then you've got so-called most favoured nation clauses, which also can have anti-competitive impacts. We've got a number of investigations underway. Our current court action against Peter's Ice Cream is one such case and relates to the alleged potential harm from exclusive distribution contracts. We're going to look to leverage this work as much as we can to address this concern in a general way. So those are the first two. I mentioned financial services, the third competition priority. We're going to collaborate very closely with the Council of Financial Regulators. Our relationship with the Council of Financial Regulators, that's the RBA, ASIC and APRA, and Treasury, has never been stronger. Well, for many years it didn't exist really, but so pretty easy to be stronger, but it's very close working relationships. We're contacting those players all the time. We've got a particular focus in competition in payment services. Obviously, people are increasingly using credit cards. I'd be surprised if most of you actually had any cash on you. You don't even use cash to buy a coffee these days. And one of the core issues affecting competition in the payments markets is least cost routing, which matters enormously to small business. It allows those businesses to choose which network will process their debit card transactions, which allows them to pay lower fees. In March 2021, we accepted a court enforceable undertaking from Visa to address concerns we held that Visa may have limited competition in relation to debit card acceptance through its dealings with large merchants. We'll continue to investigate similar allegations of anti-competitive conduct designed to limit the take-up of least cost routing by other participants. Now, the proportion of payments through digital wallets on mobile devices has also increased during COVID, and we're looking at several issues there. We're considering, for example, whether there are competition concerns with Apple's practice of restricting third-party access to its near-field communication technology on mobile devices and the terms it imposes for use of Apple Pay by third parties. And there's also a lot of policy work going on in payment systems and the financial sector as the financial sector adapts to the digital world, and we're going to play a very close role in that, working with the Council of Financial Advisors. Then turning to digital platforms, we do have active competition investigations underway in relation to payments, search, apps and ad tech. But as you've heard me say before, we're increasingly concerned about the ability of enforcement action to effectively deal with these issues. Not only are enforcement investigations lengthy, 5 years between start and finish would be a good effort, but almost more importantly, you have to narrow down the case to win, and ignore the broader implications of the conduct. And so this is really tricky when you've got digital platform cases where the market power is entrenched and multifaceted. It occurs through many, many mechanisms. There's a risk that, like I suspect is happening overseas, you can effectively engage in whack-a-mole, where you whack the mole in one place and it emerges in another. And so you can take some great cases, but you haven't actually done anything. The situation hasn't changed. And I suspect if all we do is rely on competition law enforcement, that will be the outcome in relation to these many competition issues in relation to digital platforms. So on Monday of this week, I released a discussion paper that canvasses various approaches to what's called ex-ante regulation. I just add two quick things. Ex-ante regulation is not new. Look at the banking sector, the telecommunications sector, the energy sector. They've got it to burn. And secondly, this is happening overseas. So we either climb on the bus or the bus leaves the station without us. So we're not, unlike the media bargaining code where we did something nobody else has done, this is happening all over the world. We're completely linked into it. And so we need to be part of all that to shape it and make sure that it works in the interests of Australia. Turning quickly to product safety as the clock winds down. We've had a lot of successes recently. I think the near 100% recall of Takata airbags was just fantastic. But even more so, the world-leading, world-first safety standards for quad bikes and button batteries. People said, well, why does it take so long? Well, nobody else has done it before. I mean, you're trying to come up with a safety standard on button batteries in thousands of products. It was pretty tricky, but I'm very proud that we got to the bottom of both those two things. Took a lot of time, but was fantastic work. And so we'll be following up to implement those and make sure they work as intended. But we're also going to keep advocating for general safety provision. I always slightly enjoy when you go on radio and you tell the announcer that there actually isn't because most people think there's a law that requires goods they buy to be safe, but there isn't. That really takes people aback, and Australia's really lagging behind other countries in that regard. So we'll advocate for that. A key thing we'll be implementing, we're really pleased that the government has made the mandatory standards under consumer law much more flexible so that we can more easily adopt international standards and adapt as they change. This is just a fantastic innovation. We're going to have much better safety standards, much more up-to-date safety standards because of that. It also obviously suits an agenda of more efficient regulation as well, but from a product safety point of view, it's just terrific. Now, I won't dwell more on product safety. Our priorities will come up at the National Consumer Congress in June, but we will probably be announcing priorities in relation to children's products and also tackling issues related to lithium-ion batteries. Excuse me, they have burnt a few houses down, so they are a bit of a concern. Sorry, I've been talking an awful lot the last few days. Just briefly on a couple of other topics, the NBN. It's obviously built just in time for the pandemic, so my congratulations to NBN for pulling that off. Very helpful. But we're now involved in the regulation of NBN. We put out in December a number of key outcomes from our extensive consultation process, and we're hoping those influence the frameworks, the future regulatory framework approach. Obviously, we want to balance making sure NBN has the money it needs to invest and meet its financial needs, but make sure users don't face price shocks and are not paying more than they should. As I've said many, many times before, we've got this fantastic asset. We've got to make sure now we get the best use of it. The costs are sunk. Let's make sure it makes the optimal contribution to Australia. Look, we'll be doing work on regional telecommunications. There's just been a review completed of that, and that's really important because telecommunications outside the main cities is a really important issue. So there'll be more work going on there. And I have to mention the recent agreement between TPG and Telstra to share their regional mobile infrastructure. We are going to have to examine that extremely closely to look at its implications for mobile pricing and mobile coverage. It's a really complex matter, so that's going to be a key item on the ACCC agenda in the coming year. Just briefly on airlines and airports, we're going to be putting out our report on airports, where we try and provide a bit of transparency over how the monopoly airports charge their users and conduct themselves. But we're also going to be looking even more closely at the airlines. Obviously that sector's been whacked badly during COVID, but we have seen Rex enter capital city routes, and we've seen Bonza, interesting name that. I think that's probably invented by foreigners. I'm not sure an Australian would use that term anymore, but that could be wrong. Maybe 30 years ago, 40 years ago. But anyway, Bonza is going to fly routes that largely have never been flown before, leisure routes, and we're going to be doing two things. One, continuing to advocate that whatever their chances of success, they shouldn't be failing because they can't get slots. That is, we should not use the slot arrangements to protect the existing competitors, and that would just be outrageous. And also to make sure that Qantas and Virgin don't adapt their flight patterns to try and kill off the new competitors. And look, we've got some interesting work on monitoring to make sure that the reinsurance pool that the government's introduced actually benefits consumers, and so that's going to take a lot of effort. Look, just very quickly on mergers, I was delighted to launch the ACCC's ideas on merger reform, which we think is necessary. We don't think our merger laws are up to scratch, and we intended then to start a debate, and I'm delighted we have, and that debate will continue. So that will be interesting. But look, I'll jump ahead, I guess. But well, I think it's worth mentioning that the challenges we face were highlighted by the Virtus Adora merger, where they gave us a courtesy notification of the merger, but largely went ahead with it and didn't wait for us to conduct a proper merger review. We were successful in seeking an injunction, but that was incredibly resource intensive, and most laws overseas just would not allow that to happen. So we do have deficiencies. They are a problem. We've got a huge surge in merger activity at the moment. I imagine keeping many of you very busy. What's interesting is that more of those are complex international mergers, and so we're even more than usual working very closely with our overseas counterparts, who I'm delighted to say we have very good relations with, all due to the fact that ACCC staff get on the phone at midnight because that's the only time that works for the Europeans and the Americans, and we always draw the short straw, as I'm sure all of you find when you're involved in such calls. So look, those are the priorities, but obviously we'll be flexible. If matters come along that we feel need to be dealt with, we will. So those priorities don't describe everything we're going to do. So look, to conclude, I am of course shortly leaving the ACCC. Liza Carver mentioned to me before the meeting that most of you are here to make sure I'm actually going. It's true, I'm going 2 weeks. 1 day, 1.5 days. I could go to the hours and the minutes, but I'll spare you that. So this clearly is my last speech as chair for most of you. I think the 11 years have gone stunningly quickly. I think all of you, as you get older, the years just go faster. I think it's just the smaller percentage increment that does it. But anyway, the 11 years have gone very quickly. I really want to thank you all in the competition and consumer committee, the community, right? Make sure your competition and consumer lawyers, unless you never work on a consumer issue, in which case you can just say your competition. But I want to thank all in the competition and consumer community for your insights, your dedication to making sure markets work properly, and your friendship, which I've really appreciated over the 11 years. We've had our disagreements, but they've always been dealt with goodwill, and warmth and mutual respect. So I think the relationships between the ACCC and the people often on the other side of the ACCC or outside the ACCC, however you want to describe that, is excellent and probably works better than any other country that I've observed overseas. So thank you all for that. I am delighted that I'm leaving the ACCC in excellent hands. Gina will be taking over. Liza's joined us. She's been here for 2.5 days. But seriously, it's wonderful after 11 years to leave knowing that the place is in such good hands. That's something I really value. So, look, I will maintain a bit of an interest in public policy issues, which occasionally might drift to competition and consumer issues. So I'm sure our paths will cross. So it's not completely goodbye, but it's goodbye as Chair of the ACCC. Thank you very much. Luke said it was impossible to open the bottle.
But clearly sprightly enough to jump up and down a 1.5 metre stage. Thanks very much, Rod, for that presentation. And I think, you just speak so clearly and you cover so much, but I think generally the highlight's the Q&A session, so we'll kind of move into that. I'm seeing some questions come through. I have a slight tech issue that I can only see some part of them, but I might resolve that as we go. Anyway, so look, that's a kind of prompt to have a look at the questions that are coming through and place your votes. I think I have the right to kind of kick off, Rod. One of the challenges that I think is kind of through the priorities and policy update that you've just outlined is getting a balance right around moving from a whack-a-mole situation to actually thinking about more broadly kind of policy or other reforms that could be implemented to deal with a particular issue, competition, consumer protection. But we know those processes are uncertain and they're long, they can have long-term, to come off. I mean, how do you kind of balance that in terms of, using the existing instruments that you've got, even if you might be frustrated with them, and making those work, versus maybe just holding off and waiting for a policy reform to come through? And I know that's a very open question because you've got a very broad set of policy reforms that you put on the table, but it does seem to me that you've got a here and now issue about how you deal with that.
Yeah, look, is that working? Yeah, it is. Look, most things we deal with can be dealt with by the existing laws. Most issues that we see, we judge there's a breach of the Act, and if we're successful in court, then that sends signals. And another thing I'm very grateful to many people in the room for is you quickly advise your clients about what can and can't be done, and we get the change we need. So the basic competition consumer laws work pretty well. I know I keep talking about the need to change them, but I don't want to get away from the fact that they do work pretty well. And many other issues we deal with can be dealt with. I mean, we're dealing with the regulation of the NBN, but we've got a process to do that and the powers to do that. I think, and tell me if I'm not perhaps picking up, but I mean, the problem with digital platforms is I don't think the processes will work. And we've had this before. In the early 90s, government thought about whether Telstra, as the owner of the copper wire, obviously we wanted competition, particularly with Optus. Optus needed that copper wire. You couldn't provide the service without having access to the copper wire. There was an active discussion about whether we'd rely on misuse of market power. So, Optus would go along, perhaps Telstra would say, no, I won't give you access to the copper wire, and you take them to court under the misuse of market power provisions. The view was formed then that that would not be enough. That would not work. Telstra had such a stranglehold, they could tie you up forever, and in some ways did, but eventually we've got a very active access regime, telecommunications specific, and a whole range of, a whole regime, which is actually a very strong regime, courtesy of Sol Trujillo, who bequeathed this very strong regime on the Australian community. So there was a judgment made that you couldn't deal with those issues that way. And that's very similar with laws you've got in relation to banking and energy. I just think with digital platforms, that is where we are again. Now, it's easy to say, hard to work out exactly what those laws are going to be, but they've been debated in the EC for nearly 2 years now. They're being debated actively in the UK. They already exist as law in Germany, even though they haven't been used. So I think it's going to be a tricky balance, but I don't think there's no doubt we need them. And by the way, if we don't have those ex-ante laws, we'll be probably one of the only main countries that doesn't have them. So we'll look like a bit of a goose, I think. But getting them right will be a process of trial and error. And that's why I think some sort of flexible process will be needed to get it right, but it's essential we do.
Maybe if I would sort of have a follow-on from that, and particularly around digital platforms, I mean, they're characterised fundamentally as being global business platforms. Maybe they're not in all countries, and some of the consumer competition and other issues relate to kind of global business practices and interaction with other global business enterprises. And so these rules and behaviours and platform business aspects are kind of global. How do you think about that in terms of where you put, say, an enforcement priority in Australia? What do you maybe leave to be worked out in Europe or somewhere like that, and where do you put your efforts on the ground here in Australia? How do you work that out?
Well, I'm not quite sure how we worked it out, but what we decided, because we looked around and we saw cases being taken, particularly in Europe, we were very keen to get the market study we got. We were talking to the Department of Communications, and then, of course, there was media issues came up, and that facilitated the inquiry into digital platforms. That it was certainly, of all the inquiries the ACCC's done, that was the one we're angling for. Most of the others, we were walking down the street and they were plonked on us. This one we actively wanted. And so we felt that what was needed was trying to bring some transparency to how they operate. I mean, you had these cases in Europe, and there were a number of them, but they were narrow cases. They weren't actually explaining how digital platforms work. They weren't giving you a good understanding of how ad tech works. I mean, none of that. Some of the issues with apps, we've been able to bring out some of the arrangements in search. So we felt we were best able to provide some transparency rather than resources on competition cases. And then, of course, we have got 3 consumer law cases, because we felt that digital platforms raise both competition and consumer issues, and we felt we had a real comparative advantage in consumer cases because we're quite a vigorous enforcer of consumer law. We've actually got penalties for the breach of consumer law, which they don't have in the US and the UK, which just is unbelievable. So we just made judgments about where we could contribute most.
I mean, it's, I guess in a simple way, that's just looking at Australian consumer harm, right? So, and using that, and as a particular kind of measure, right? So there are particular matters where you see some direct impact for Australians that might be specific in Australia or require some correction. Do you see is that just likely in consumer protection cases, or do you think there might be some competition law issues that you're looking in the digital space that have some Australian-specific aspects?
I don't think much of what we did was Australian-specific, Luke. Okay. I think most of the platform inquiry was describing things that were equally relevant overseas, and I was... the one thing that surprised me more than anything in this job over the past 11 years was the positive reaction we had internationally to that platform's report. I mean, it was a good report, but it's just been the recognition of it overseas has been terrific.
I think you haven't landed my question. I was really referring to your enforcement actions that you focused on.
Well, yes, I guess so,
Enforcement actions
Luke, but the, apologies, but the location case could have been taken anywhere in the world. There's nothing specific to Australia about that. The Facebook and Arvo case, likewise, and the Google DoubleClick case. Those cases could be taken anywhere in the world. Of course, they're Australian law cases, but we didn't actually, I mean, there's not much, as you said before, with digital platforms that is peculiar to one country. Most of what you're dealing with is international, and that's why we're constantly talking to our counterparts overseas.
All right. Rod, I'll just pick up some of the higher vote questions here. One question, which I think in some ways you answered, goes to the cartel investigation, and the question directly is an update on how many criminal cartel investigations the ACCC is working on and how many criminal cartel lawsuits it plans to refer for prosecution, bring to court in the coming year. And that's a very specific question. Could I just add my rider to it? Is there another way of thinking? I think you expressed a view from a cartel enforcement perspective that it's disappointing to see ongoing conduct, and I'm sure everyone in this room would agree about that. But are you not giving yourself full credit for a measure of success, and has there been really a fundamental change in the level and nature of some of that behaviour, and actually has the ACCC and overseas agencies been much more successful than you may be sort of giving yourself credit for in driving?
I'll take the credit in the shot. Okay. Luke, that's fine. I can only agree. Look, these cases are tricky. We've, I think, had outcomes in 8 criminal cases, and we've been successful in 5 and not in 3. We have got matters with the CDPP. I'm not sure I can even answer the question as to how many, but I've only got probably a couple actively with them at the moment. But we've got a number of investigations underway, and we've got to make judgments about what's criminal and what's civil, and those are complex judgments. We've got quite a number of civil matters before the courts. I think the BlueScope hearing is now finished, but we've got a range of 2 or 3 others before the courts. So that's when you think about the sector coverage and the number of companies, that's quite a lot of cartel cases. But look, there's probably only a couple actively with the CDPP at the moment.
The other highest vote question is quite specific to compare the market websites. There are many compare the market websites that some commentators suggest limit the number and type of providers. To what extent do these sites engage in dark patterns, and how can a consumer know?
Look, we've done a fair bit of work on comparator websites, and we recommended in our electricity inquiry that there be a mandatory code to guide how those sites work, so that they disclose whether or not they're covering everybody, whether or not they get what the financial arrangements are between the people who run the sites and the companies advertising their wares. So we've already taken quite a number of steps there. I don't think we're seeing dark patterns there. Those dark patterns are more general in relation to the platform companies and other marketplaces, particularly, see, for dark patterns to be really powerful and important, you've got to have the data. That's the issue. I mean, back in the old days, there'd just be these ads which would advertise to everybody in this room. Now there's ads that are targeted at you as an individual, how you're feeling at a particular time, whether you're thinking about buying something. They've just got an enormous amount of data about you, and they can use that to influence you. Now, some people might think that's fine, but I just think it can't be a free-for-all in those sorts of activities. The data and the use of it has got ahead of the regulatory framework. Again, my own view is that an unfair practices provision is the better way to deal with it. And I know I'm getting off track a bit, but the alternative to an unfair practices provision is government legislating, saying don't do that, don't do that, don't do that. It will be incredibly intrusive, but you're going to have to go one way or the other. It's not going to be unregulated. So those who don't want much regulation, then jump on the horse that's called unfair practices provision, because that's the best horse in the race.
Well, that's a lot of insight into that observation. Rod, I'm sure that the warmth of your comments for this audience at the end, I'm sure, would all be reflected back to you. And really, I think in this audience there'll be a very genuine interest to know what next for Rod. And you touched on it in a general way, but maybe if you're able to share more about what next for Rod.
No, well, thanks, Luke, because I have been getting a lot of people asking. So, thank you for all those wonderful emails wishing me a good retirement, but that's not happening. I'm going to be doing a couple of things in a very relaxed way, I emphasise, but I'm going to get a professorial role at the Crawford School at ANU, which deals with public policy, which is something I'd like to spend more time on. That'll be my main base, but I've also got a link with a competition research and policy network based in London and Europe. That's part of the Centre for Economic Policy Research, and that's got about 35 internationally renowned competition economists, no Australian ones yet, which I intend to change. And it is a network, it's not an organisation, so it's just a bunch of people to chat to and talk about international antitrust issues, not cases, just high-level direction stuff. So I'll still be a bit involved in that. So those two things will keep me happily amused. Thanks,
right,
Luke.
We look forward to watching that. Well, that brings us to the close of the Q&A session, and I'd like to just invite incoming ACCC Chair Gina Cascott-Lead to come up and make some closing remarks. Thanks, Rod.
Colleagues and friends, over the past 20 years, CEDA has welcomed ACCC chairs and many commissioners to address the CEDA members on a wide range of competition enforcement and regulatory matters. That's include Alan Fells, Graham Samuel, Rod Sims, and each have spoken on a variety of topics within the ACCC's remit. Since 2013, Rod and the ACCC have used this forum to launch the ACCC's compliance and enforcement priorities at the start of each calendar year. As Rod has described and emphasised today, this is a key opportunity to be transparent about areas of concern and enforcement focus, and to encourage, foster and prompt enhanced compliance. So this is a baton change moment for the ACCC. We maintain the same clear purpose, the same pace, and a high-performance, capable and diverse team committed to the safety, interests and welfare of consumers and the maintenance of effective competition across the Australian economy. As Jet noted in her opening remarks, CEDA's purpose to improve the lives of Australians by enabling a dynamic economy and vibrant society, and CEDA's method to apply economic analysis to practical problems aligns very closely to the ACCC's mandate. As Rod has outlined today in the Commission's 2022 to 23 priorities, these reflect issues critical to the continued dynamism and growth of our economy and the welfare of our community at a time when we are all very concerned about volatility, uncertainty and rising issues such as supply chain performance, the multiple impacts of the COVID-19 pandemic, environmental sustainability and access to and cost of services essential to production, distribution, communication and payment. Both in his address but also in the Q&A session with Luke, Rod reflected the breadth and depth of scope and global reach of these issues. Everyone here is very conscious of it, very engaged in it, reflect in each one's own business, one's own advisory work, one's own representation of consumers, key aspects in these issues. Today is a great example for us all of Rod's vigour, dedication, activism and unrelenting hard work throughout the 11 years of his term. Dr. Alison Pert, international lawyer and Rod's wife, has told me that Rod works 9 days a week. Fortunately, private practice, including 25 years at Gilbert and Tobin, has given me some training for this intensity. I acknowledge and thank Rod for the significant contribution the ACCC has made under his leadership to our economy and, importantly, to the public understanding of how critical competition and consumer protection law and policy is for our country. As we all heard, this is advocacy that Rod promises us, and we expect him to continue. Finally, I want to thank CEDA on behalf of the ACCC for this opportunity to herald the ACCC's priorities at the beginning of each year. I look forward to continuing this tradition. Now, back to you, Jet, to conclude. You're going to, Luke?
Yes, it's me.
Okay.
Thank you very much, Gina. It falls to me to close today. Unfortunately, Melinda Salento was unable to join us from Melbourne for probably reasons most people can sort of see outside. But I really would. I'll just give you my key takeaway from this discussion. I think it's reflected from Gina, is just how hard the ACCC works to remain relevant, how much and how relevant they are in a very fast-paced, changing economy, and it's a great credit to them, and it's a hallmark of your leadership, Rod. So I'd like to formally thank Rod, wish you well in terms of your departure from the ACCC, but we no doubt will see and hear much from you soon. I have the task of sharing the results of the poll question. Are they up there? This was a question giving kind of a look-back assessment of the Commission's people's assessment as to the performance against the last year's priorities. I can't actually see it. Anyway, look, I'd like to thank the attendees today for your attendance and the participation through the Q&A. I'd remind attendees to stay in touch with CEDA's programs via the CEDA website, and I think some of the upcoming events will be shown on the screen, and I'd like to bring the event to a close. Thank you very much.